Yeah.
Okay, Robert, we're going to start on the one that we missed last week. And I've now done some more homework on the Breonna Taylor updates to... Okay, so, I mean, there has been new evidence in the Breonna Taylor situation, which it's an interesting thing. It may not change my ultimate conclusion, and we'll get to it towards the end of this segment. But the information has been earth-shattering, I think, on both sides, because for anybody who doesn't watch Tatum, I forget what his first name is, but Tatum Report has all the new evidence. Oh, sorry, say that again?
Brandon Tatum.
Brandon Tatum. It's amazing stuff. It's informative. You may not like his political, I don't call it ideologies, but I like, it's good information. So there's new evidence showing that Breonna Taylor she was an EMT, but there's some evidence showing, she might have been more involved in everything. And I'm mincing my words. She was more involved in everything in an active way. Text messages between her and her ex-boyfriend, her current boyfriend, showing that she was actively involved, knew what was going on. There's pictures of her, holding firearms, which, even Tatum says this is not a Second Amendment type picture. This is a different type of picture. So there's that evidence that came out, to undermine the innocent victim narrative. The flip side is there's other evidence coming out to show that, I forget which police officer it was, but basically the police force admitting that they might have misled the judge on the warrant in terms of justifying the warrant, that the policeman who got shot in the leg might have been shot by friendly fire and not by Breonna's boyfriend. So, okay, where do you go? What do you do with this new evidence? Where are you at now in this case?
So it's a couple of different things. There has been more information, and I assume some of this coming from Louisville PD, that Breonna Taylor was attendant to, if not involved with, the drug culture. And that Kenneth Walker may have been attendant. What I mean by it is around it, sometimes inside it, sometimes outside it, not an integral component, not something that they permanently did, but associated with it. And then there's social media photos that are the kind of what Tatum's referencing is they're the kind of photos you signal if you want to say you're part of that subculture, or at least affiliated with it, attached to it, connected to it, want to be associated with it. And so that's the evidence that's come out on that, and including text, including older conversations where she knew, Nate the lawyer did this detail. She knew what a trap house was. She'd been to the trap house. She had communications, et cetera, back in the day. So the idea that she was just an EMT, the cops randomly raided for no reason, no purpose, no cause, and shot her was, always a BLM exaggerated story. That was true. That was evident from the get-go. You could just know a few things and know that was not likely accurate. On the flip side, my suspicions of a Louisville Police Department cover-up have intensified and amplified after new evidence and information has also come out on that side. So sort of the backstory for folks. I didn't pay a lot of attention to Mitch McConnell. I knew that there were Republican critics of him, people like Steve Bannon and others, who considered him the main problem with getting anything positive through Congress, both before and after Trump's appointment. And if you want to know, folks, why is Chris Wray at the FBI? Why was Rod Rosenstein number 2 at the Department of Justice? Why is Gina Halper over at the CIA? Why was Dan Coates as Director of National Intelligence? All these people that were sabotaging and undermining Trump. People like Tillerson at the State Department. People like Mattis at the Defense Department, who are conspiring with ways to actually literally overthrow Trump. That information has come out since. Why is it all these people? Now, I've been critical of some of Trump's choices because I think he's delegated that to other people, but I can't be too critical of the ones that require Senate consent, because that's heavily dictated by Mitch McConnell. And so so that's issue one. Issue two, I became more familiar with Mitch McConnell in the Covington case, because I donated my time voluntarily, pro bono, was willing to help whomever, whatever they wanted to do. I was only interested in bringing a certain kind of case. So if they were interested in that, I would help them out. If they wanted something else, they should seek out other counsel. And but astoundingly, very early on, I started getting blowback. I started getting smear campaigns being waged against me in Covington, smear campaigns. Even Tucker Carlson was effectively part of it. He put on a lawyer who was just there to attack me, there to tell all the congressmen, don't worry, you can't be sued, which was a very peculiar thing to say. But yeah, Tucker's a dope when it comes to legal analysis. He always has these insider types on. I always call him the preppy populist. I love his rants from a populist perspective. But if you know Tucker, he's still a bow tie boy at heart. And so his political crowd is still the Martini crowd. It's still the Chardonnay at 6 crowd. He makes fun of them, but that's who he's associated with. He ain't hanging out. Oh, by the way, you're on mute. You're still on mute, Viva.
Yeah, I'm an idiot. No, I'm saying I gotta bring you back to the Breonna thing before people start getting frustrated that we need to know what you're making of the new evidence. So first of all, if I may, so this all leads where? Because there's an idea of Louisville corruption among the police force in this.
Well, it's important to put why did I have suspicion or skepticism of the Louisville Police Department initial story and the Kentucky Attorney General's actions? It's because what ties all of these things in. It's all the crap I was dealing with in Covington was connected ultimately to people that were allies of Mitch McConnell. The Attorney General for Kentucky, who has spoken at the Republican National Convention, was a longtime Mitch McConnell aide. The U.S. Attorney for that's doing the civil rights investigation of Breonna Taylor was appointed with the consent of Mitch McConnell. So if you were going to do a cover-up, so to sort of give people an anatomy of a cover-up put Breonna Taylor in context, you can think what you want about it. But part of my goal here is to sort of educate people on how to preview a cover-up, how to understand whether it might be occurring, what to look for, what's the formatting, what's the structure. First reason I was suspicious was $12 million settlements don't happen out of the gate. So I've seen people comment in the comment section, oh, no, they did it for political reasons. I've been involved in high-profile, heavy heat civil rights cases. The maximum they offer is $2 million. Okay, the $2 million is the high end of verdicts for wrongful death police shootings. On average, it goes $1 million or less. So the idea that you would pay $12 million out of the gate just because you felt political pressure is just nonsense. It has no historical bearing. That's not the likely explanation. When you pay that amount before discovery, it's purely a bribe. It is what it really is. It's, hey, if you agree not to do discovery and you agree not to expose whatever would come out in discovery to the world at trial, we'll give you a huge bonus, because this $12 million won't be available if you go through with trial, because then you're only going to likely get $2 million, and you'll get your fees. Maybe that'll be another $1 million, but that'll be $3 million. You're not getting any $12 million. Only way you get $12 million is if you agree to be nice, be a good boy, sign the settlement, don't go to discovery, don't expose this to the world, and we'll write you a ridiculous check up front. So that was the first reason to be suspect. Second reason to be suspect is if you looked at the problem. In other words, here's the thing. People connected to McConnell would have complete control of this case except for that civil rights case. Breonna Taylor's civil rights case is the one his people did not control. That meant if you wanted to do a cover-up, you had a problem. You had this loose link of where information could get out, where information could cause problems. You needed to settle that quickly. So by writing a ridiculous check, you could make sure that now only 2 people were going to control the case moving forward. The Kentucky Attorney General, longtime ally of McConnell. And even if they weren't doing this for McConnell, they operate the way McConnell operates. He's a great, knife fighter behind the scenes, but he operates in a certain political insider ballpark kind of way. And the second you would do, and put it this way, he is the number one reason why nothing has happened. It isn't Barr. It isn't Durham. The number one reason nothing has happened on Russiagate is Mitch McConnell, because he doesn't want it to happen. That's why he chose who runs the Judiciary Committee. He chose who runs the Intelligence Committee. So McConnell is the hurdle. So that's just a reality check for people out there. But so he's the kind of guy to actually spend time controlling things. If allies of his would spend time worrying about whether the Covington kids ever sued an individual journalist that was friends of his or connected to him, or a Congress member, imagine what he might do in a major political scandal in his home state when he's up for re-election that year.
So I'll ask the obvious questions. We know sort of some of the information that's coming out now, say, that looks bad for the police, but what could there be in there? I mean, you're probably just going to be hypothesizing, but what could there be in there that's so damning that they don't want it to come out in discovery? What sort of level of corruption? What sort of elements of corruption? A judge not looking at an affidavit properly, falsifying the information to justify the affidavit. What sort of corruption could come out in discovery in a wrongful death lawsuit?
Oh, okay. So let's get to that. So the information that could be there would be information, everything that went into the raid, number one, in terms of whether true statements or false statements were made. Did they actually have probable cause? Did they lie and perjure themselves to get the affidavit in the first place? Did they execute? Did they have a plan for the execution of the warrant? Everything related to that, number one. Number two, what if the shootout was almost all because of cop reaction rather than anything, and there was cop panic rather than any reaction to what was happening inside? So you have everything that goes into the warrant. That's where you have a lot of risk if there's potential of perjury and the rest. The second area you have risk is the planning for the execution of the warrant. The third area you have risk is the actual execution of it. Did they actually announce or not? Why did they go in at 12:30 if they decided to do knock and announce? Why did the people that were assigned to it not know much about the case that were doing the execution of the warrant itself? So you have that aspect. Then the fourth aspect is what actually happened. So here's one version of events that could be the case. They came in there, they didn't announce, or at least they knew that the people weren't hearing their announcement for whatever reason. They decide to ram and knock through the door. They hear a shot, but maybe that shot doesn't actually hit anyone. And they panic and just start gunfiring the entire apartment, including people outside the apartment shooting randomly into the apartment. Other people shooting randomly, not knowing. They're outside the apartment, not knowing even what they're shooting at. And then after one gets shot, they pull them out, and they're all outside with some of them machine guns ready to shoot in, and maybe some did fire from even the parking lot. Well, then you have a crazy disaster scene for the Louisville Police Department. You have a raid that maybe was based on perjured testimony, that was executed without a plan, that was enforced and contrary to what they themselves said, leading them to make false statements later. Then you have false reports being filed that say that there was no forced entry, that the person who died from someone else's gunshot. Let's say maybe you had a Louisville Police Department officer saying that Breonna Taylor was killed by her boyfriend, not them, and they just happened to find it there. Those kind of stories where you have lots of officers lying, lots of officers not doing their job, lots of officers even lying under oath, and a wild shootout where they shot who knows who, and they were ready to blame it on other people to exculpate themselves entirely.
You know, I mean, I've made the reference. I guess we're early for our first movie reference, but the way this could have been bungled in theory, if it went the way I think it might have gone, is like reminiscent of Copland, where, you know, the tire pops and then someone thinks it's a gunshot and then they open fire on the car, and then to justify it, you know, put a gun down and say that, you know, we found this in the car. EMT says we didn't, you know. If anyone hasn't seen Copland, it's not a very good movie, but it's a memorable scene.
Oh, it's a great movie, and you got to make the first movie reference.
Well,
so that is a great movie to recommend. Sylvester Stallone plays, you know, against type character that's just off the charts. There's one of those one of the cop actors is actually
Michael Rappaport is in this movie, right?
Yeah, he's the guy almost sued related to Covington, but then he pulled back his stuff. So but he's really good in this movie. Harvey
I haven't seen it since I first saw it 25 years ago, so maybe I might view it differently now than I did then. But so, you know, so when the story first comes out, ABC reports they're at the wrong address, total hogwash. Other mainstream media says she was sleeping, total hogwash. But it comes out now, so okay, you know, maybe she wasn't as innocent as it was initially led to believe. But then the question's still going to be, notwithstanding all of that, is it in fact the case that they show up, don't knock, one of the cops panics, shoots his buddy in the leg, his buddy thinks he got shot by the guy, they open fire through the doors, even if they are bona fide drug dealers with pictures on the internet and this and that turns into a bungled execution of what might have been an ill-gotten warrant with an improper plan. And so is that what they're looking to, you know, avoid to see the light of day by paying $12 million you know, a month into a lawsuit?
Correct. And what it could implicate lots of other people. That when you have you see, for example, you may have a cover-up believing that the case looked bad without them even knowing whether it looked the way they thought it did. So you might have high-ranking officers involved in covering up information, lying to their superiors, lying to judges, lying to third parties, lying to the press. So this could go far, wide, and deep. And let's say you're nervous and you're in Mitch McConnell's world and you're up for re-election in Kentucky and you're worried this could go AWOL and you're a control freak at heart. You might make sure that there's no loose ends and that your people control where this case goes from going forward. And he achieved that. Or let's put it this way. Even if that wasn't his objective and he had nothing to do with it, that sure was the outcome. The outcome was civil settlement case gone. And instead, his guy at the Kentucky Attorney General's office and his guy at the U.S. Attorney's office controlling it moving forward. Now, let's go to what we now know was indubitably part of a cover-up. The Kentucky Attorney General pretty much lied to the world. He went out and came out to the world, and he told them that he just gave all the evidence to the grand jury. He gave all the law to the grand jury, and by golly, they just made an independent determination. Now, those of us who are as defense lawyers were inherently skeptical of that presentation because there's a reason why they say grand juries will indict a ham sandwich if the prosecutor asks them to. It's because grand juries do what prosecutors ask them to do. It's very rare they make a truly independent decision. But that's what he was putting out there. Well, it turns out he lied about pretty much all of that. He actually instructed them only on the one charge that they indicted on, did not ask them to indict on anyone else, did not give them instructions on the law on anyone else, did not even advise them of the relevant self-defense laws that applied to Breonna Taylor. Because under their presentation of evidence, Walker shot first, and then he dived into the second bedroom when shots came back. And that's why he wasn't hit. And Breonna Taylor was hit by all of the other police fire. But by that evidence, by the way, in Kentucky, and the same self-defense law applies whether it's a cop or not a cop for the state criminal prosecution part of it. It's a different analysis if you kill someone who didn't shoot at you. So for folks out there, think of it this way. Let's say you're in the park and a drug dealer runs by and shoots at a cop. That does not entitle the cop to just start spraying the entire park and kills you. That's not self-defense, even though the drug dealer shot at him first. So there's certain and for a cop, it's a higher standard because of certain sort of training and procedures that they should employ in that situation. So what he should have instructed the grand jury is you can prosecute any of these police officers on the shooting of Breonna Taylor if you believe their shots may have killed her. Number one, he didn't do that. Number two, he needed to give them ballistics evidence about all of what ballistics were there. He didn't do that either. The ballistics test came back and was inconclusive even on the bullet that went into the police officer. So when people say, oh, we absolutely know that it was him, no, we don't. Not according to Kentucky's own ballistics test. But he didn't have ballistics. He decided to isolate, quote, the one bullet that killed Breonna Taylor. How did he identify that when she was shot 6 times? See, that's a sign of a cover-up attempt, folks. You identify all 6 bullets, and then you give them information. When you try to isolate one bullet and pretend it's somehow the magic bullet, and coincidentally, it ends up not coming from the gun of the guy who literally shot up everything. By the way, Nate was right. That third cop who was shooting from outside, when Nate said, the risk is that you're shooting at cops, that's exactly what he was doing. He shot at the police officers. He shot into the neighboring house, which had no connection to where she was at.
And it's another. I mean, this is why I say it's not out of stubborn pigheadedness that I don't want to change my position and admit that I was wrong. First of all, it was Sarah Shelton asked if you thought Cameron misled the grand jury. I think the answer is yes.
Yes, okay. He lied to them. Well, let me change this. He lied to the world. What he did to the grand jury was hide information. He didn't give them all the evidence. He didn't give them the choice. He didn't instruct them on the law. Now, he has no legal obligation to do that, by the way. So he avoided any criminal action. He didn't mislead the grand jury in that way. He misled the world about what the grand jury was authorized to do.
Now, and he presents a weak case to the grand jury, I would say not all fabricated or altered, but he'll present a weak case with insufficient evidence, knowing the grand jury then is going to not elect to indict. And then they walk away, and the other guy from outside gets charged with something, minimal in the sense.
He didn't even give them the choice. He said, "Here, our recommendation is a wanton reckless prosecution on this one guy for endangering other people." So that for folks out there, grand juries are used to doing whatever the prosecutor asks them to do. He didn't say, "I now want you to consider whether or not to indict these other people." He didn't even give him that option. So that's why grand jurors were mad so quickly and were going to court wanting to release the records. Because when he decided to hide behind the grand jury, The grand jury was like, hold on a second. You didn't give us even that alternative. You didn't tell us.
You got to imagine it's an amazing thing. The grand jury gets doxxed or something along those lines. Then people are going to blame them for not having done what they think they ought to have done. They're exposed. And so they have an incentive now to say, like, we want the world to see what we saw because we made the decision based on what they presented us and what their recommendation was. Andrew Hill says Barnes is comparing shooting a whole park to a 3-foot wide hallway. Shame, man, shame. Well, here's the deal.
Sorry. No. That's inexcusable. This is a cop. You're going into a place. You don't start firing randomly unless you know what your target is. So I'm sorry that there's protocols there. Otherwise, you're greenlighting them to go in and shoot up a house because, hey, somebody in the house shot at us. We think maybe. We're not even sure. The cop outside was shooting in response to police shooting, by the way. He wasn't anything else.
So I might did sort of some banging up. And just to illustrate the point, let's just even assume, I mean, let's take for granted, Breonna was the one shooting with her boyfriend. If they had killed the woman in the apartment next door with the hail of gunfire, the comment holds true is that it doesn't, it might explain certain things, but it doesn't explain away the consequences or the responsibility, because she could have been, for all anybody knows, she might have fired the gun. I'm not saying she did, it's hypothetical. Even if she did, if they were to have killed the pregnant woman in the apartment next door in the hail of gunfire, nobody would be asking a question as to whether or not that woman has a lawsuit against the people who killed her.
And over half of the 22 shots didn't go to the hallway question, didn't even go to the hallway. They went in the opposite direction. So because the hallway doesn't lead to the next door neighbor's apartment. The next door neighbor's apartment was this way. That guy was shooting into the kitchen. He was shooting all over the apartment like this. He literally shot all, and he shot in response to police gunfire. He's admitted this. He said he really believed that there was here's what I think happened. They went in, they got nervous when someone didn't answer the door because they thought it was going to be a soft target. They hit a panic button. One guy admitted one of the cops described the guy that shot up everywhere was way off the charts, uptight and anxious, and they were worried about him. And here's the other problem. So you have Mattingly who goes in. He's the one who gets shot, says he shoots 4 times back, then gets pulled out. He's the one who they can't identify what the source was of the bullet that went into him. That's the Kentucky's own forensics lab, ballistics lab. The guy behind him, listen to his description of what happens. Something is off. He doesn't describe a normal thing or anyway. He describes a blackout scene. He says he describes flashes and lights and things like a movie. And it's like, okay, that guy blacked out. That guy blacked out in some kind of panic and just started firing crazy. And who knows when he started firing, because he clearly was on edge because he was worried that they're about to get ambushed before they hit the door in. So and he was right behind him. So if he and a lot of these shots came from outside. Mattingly shot 4 times inside. He would have the cleanest self-defense argument. But even then, he just shot in the direction from which he heard a gun. And he just went boom, 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 boom. That is not police training, to just shoot first and ask questions later.
And this is why I say it's not. First of all, can the grand jury do a jury nullification if it goes to them? I'm not sure I understand the question.
Well, a grand jury makes a probable cause determination or not. Do you mean, can the grand jury think there is probable cause and choose not to indict anyway? Yes, that's their political power. So and that's what he means by nullification. The law would, but again, this grand jury never thought that their job was solely to indict the one person. They didn't believe they had the choice to indict the other cops. They're asking questions that suggested skepticism of what was being presented to them. And they were just never most grand jurors do not know that they can indict whomever they want regardless of what the prosecutor recommends. And I guarantee you, if the prosecutor's evidence that he presented to them, his version of events, if that was exculpatory, he would have already disclosed it. The only thing he's hiding that he hasn't released yet from the grand jury records is everything he told them. So that tells me that what he told them was, here's what we recommend, here's what the evidence supports. Grand jurors do whatever the prosecutors ask them to do. It is an extremely rare grand jury that doesn't. And the way the grand jurors was asking questions, this grand jury came in skeptical of the police, not deferential to them. So if they would have been asked to indict other people, they would have indicted other people. If they were given the option of indicting other people, they would have indicted other people. Is my takeaway by the nature of their questions and their aggressiveness afterwards. And that's why, he was running a scam. And look, if he would have admitted it, no problem. He said, look, I investigated it. I made the determination. I told the grand jury, and that's it. Instead, he lied to the world and hid behind the grand jury, just like a Mitch McConnell protege would. And I think he ended up making a big mistake, because here's some evidence we do know. We do know there were over 26 gun casings from outside the apartment. We do know that there are gun casings all the way out into the parking lot. We do know that it appears that people were unloading and reloading clips from outside the apartment. We know that when the SWAT team showed up, they were concerned with how the police were behaving. They're like, put your guns down. What in the world are you doing? They're all out. They're all jacked up like they're in the middle of a gunfight. The police officers outside truly believed there had just been a massive gunfight when all of the shooting was coming from cops. There was only one shot that ever came from anyone at the beginning. They thought all of the other shots were coming from inside when it was their own people doing the shooting. That's what a disaster this was. And then we also know that they put in their report, the initial report, that they did no forced entry and they did not admit to shooting Breonna Taylor. So they were being deceptive from the get-go. Hankinson, sorry.
I want to bring this one up. Jim Satala says, you do realize that all the officers had 40 caliber guns and Kenneth had a 9mm and the cop was shot with a 9mm, so ballistics didn't matter. Actually, I think, Robert, correct me if I'm wrong, one of the additional pieces of information came out that apparently one of the other cops might have actually had a 9mm, which would explain the potential for friendly fire on the cop that was shot in the leg.
Yes, I mean, that's where Brandon Tatum has made some strong statements, and it's just not backed up by the ballistics evidence so far. So that's where I disagree with Tatum. Tatum is a former cop, and I understand the instincts that because BLM has lied a lot and jumped on the Breonna Taylor case late. They didn't jump on it initially. They jumped on it late when it became politically convenient to do so, and then told an exaggerated story related to it to be skeptical. That does not mean to be deferential to police universally. There's a reflexive instinct now amongst people on the right especially to just trust the police no matter what. Just to say the police could never do a bad shooting. Police could never do anything wrong. Police could never lie. Well, in 20 years in criminal defense, I guarantee you that's not true. Number one group of people that lie on the stand, in my experience, are law enforcement officers. So do with it what you want, but that I've seen it, I've witnessed it. And so anyone else who's been through it. And the 12 million was a huge red flag. The fact that all of McConnell's people were running everything after that was a huge red flag. And now we have a guy lying about what he did with the grand jury. That set up the possibility that the governor, who's Democratic, appoints a special prosecutor to investigate the case. And the only thing holding him back are the Democrats in Louisville don't want to be exposed. So so we'll see how that goes. But the U.S. attorney will only go so far in Louisville. His goal is to drag it out past election, drag it out a little bit, and then maybe bring some small charges and some institutional claims, is my hunch. Because, again, he's a McConnell guy. And I'm just saying that there's too much. Where there's smoke, there usually is fire, and here there's more and more and more smoke. And the other issue is, I mean, I didn't realize how bad Hankinson's shooting was, and maybe other police officers. Here's a red flag, folks. When they choose not to do ballistics test on a bunch of the bullets, like why did they say, "Oh, I'm only going to look at one bullet that hit Breonna Taylor"? I'm sorry, that doesn't make sense. That is not police protocol. That is not investigative protocol. That is not prosecutorial protocol. That wouldn't have happened in the civil rights case. They would have had ballistics on all 6 bullets that entered her to figure out what happened. And Hankinson, by the way, was going around and telling people that they had shown up and that he believed that Kenneth Walker had shot her in a domestic violence incident, and they just got caught in the middle of this crazy domestic violence guy. That was the kind of crazy lies he was telling afterwards. He broached the scene illicitly. They didn't preserve the scene properly. I mean, it's one disaster after the other. So we'll never know fully what happened. But when I heard that second cop's testimony, I was like, that's one of the weirdest stories. Maybe the behavior panel will do an analysis of his thing. But here's another example. They talked to Kenneth Walker for over 2 hours. They appear to only talk to the 2 cops for 40 minutes. I mean, everything about this screams cover up. Everything about it. And usually when they're covering it up, it's because there's something there to cover up.
I'm going to have to try to find the link of where I'm forgetting where I read. It was one of the additional pieces of evidence that was recently released was that apparently one of the cops did have a 9mm, which really called into question the official narrative. I don't have the source right now. If anybody can link it, that would help. And this is what I mean, like in terms of not being a stubborn pighead, not trying to admit that I was wrong. These would be one of the fact patterns where unless Breonna was shooting, that might change her claim.
Yeah,
we're operating on the basis that she was not in fact the shooter. She did not, whether or not she was sleeping, whether or not she was involved in drugs, she wasn't the shooter. Whether or not her boyfriend fired first or it was friendly fire, there was a shootout that ensued. Whether or not they're actually running a drug house does not explain away or justify the police response. And so how far does it go in terms of who should be charged and for what? That I don't know. But when it ends like this, with bullets going through the neighboring apartment of a pregnant woman with a child, obviously something went wrong, and it's not an excusable sequence of events, as if it were a single residence domicile somewhere else where they knew exactly who was in there, they knew who was firing at them, and they knew what they were firing at. So that's why all this stuff, I'm reluctant to sort of victimize the victim or criminalize the victim. Go and say, like, well, she was running a stash house, she had text with her boyfriend. All that could be true. It doesn't change the liability for what happened that particular day. But it's the information that's coming out. On the one hand, it does make Breonna Taylor look less innocent than anyone in mainstream media was depicting her to be. It makes the cops look more incompetent than anybody else was thinking they were. And whether or not this, you called it at the time, whether or not this $12 million settlement is just intended to cover up the gross incompetence from obtaining the warrant to executing the warrant, whether or not it's just to cover that up and minimize the losses for their credibility and for their stature is another issue. But so, I mean, now where does it go from here? So if Cameron misleads the world and gives sort of a loaded case, people are going to get so frustrated with you, Robert. If he
sorry, I thought I had it fixed, but now today for some reason
it's good enough. But if Cameron misleads the public, presents a loaded case to the jury, to the grand jury, what are their recourses now? They are petitioning the civil courts to be relieved of their confidentiality obligations.
Yes. So there's three things. One is there's Hankinson's proceeding. So he's been charged with the wanton recklessness of the neighbor. And so there's that judge may release grand jury records as part of that. There's the grand juror who's requested all the release of the records because they want that information disclosed. That became a First Amendment challenge that Uncivil Law actually did a video on in a Missouri case. Generally, there's not a First Amendment right to have your grand jury records disclosed, but given how politically hot it is, it may be the case that they disclose it. Now, the Attorney General agreed to disclose everything except what he told them. So he disclosed all the other evidence they listened to, and that was the giveaway. There was a lot of evidence they were directed down a particular path. And again, if he'd been honest about that, different story. He could take the heat. He could say, look, I reviewed this evidence. I'd made a determination of self-defense. Here's why. I told the grand jury that, and the grand jury decided to issue, and I presented them only this indictment, and that's the one they brought. But he didn't. He misled the whole world about it, and that's my problem. That's a sign of a cover-up. That's a sign that you're trying to hide what you're up to. That's a sign that you're not engaging in good faith behavior. And it's not a surprise. I mean, by the way, that guy was considered a rising star. There were people. He spoke at the Republican National Convention for people who want to connect the dots. He's considered like a Supreme Court potential pick, a rising star in Kentucky politics and national politics. I think he's going to regret doing this, but I think that's why he did it. And I just don't believe that McConnell didn't have something to do with it. And my point of bringing up McConnell is just context. And he tends to make these kind of decisions. He tends to cover up institutional corruption. He tends to think he can get away with it because it works a lot in Washington. And I think it backfired here because there's too many people paying too much attention from too many places in Louisville for this to work again. When you have the institutional press behind you, like you do in the Russiagate scandal, then you can get away with it. You can't so easily in the others. And to give you a connection, folks, there's a reason why I was getting hit and other people were not. It goes to look at who has sued who. So just as an example, Salmon still hasn't sued any individual. None of the people McConnell wanted to not see sued, all of those people have not been sued. So it's just to give you an idea of the way McConnell's brain works. So it was the $12 million settlement, the McConnell connection to all of this, and then we started getting more evidence of it. We got the documents where they clearly lied to try to cover it up beginning. We got Hankinson telling false stories after the fact. We got Hankinson contaminating the scene. We got they're supposed to institute strict protocols right away. If there's a police involved, here's what it was. They went to great lengths to pretend there was no police involved shooting. They were trying to tell that story to the SWAT when they showed up. They had a dog out when Kenneth Walker was coming out. They were screaming at him. They were going to unleash the dog on him unless he walked really slow. And then they're interrogating him, and then they're pretending that he did the shooting. They're like, "What? What are you talking about?" I mean, I think they panicked. I think they panicked twice. They panicked first going in, and they panicked again, wondering, "Oh, what the heck did we just do?" and they went into cover-up mode, and they are still in cover-up mode. And we don't know. Maybe it was still a justifiable shooting. What I would have liked, do what the AG said he did. Actually do that, though. Do all the ballistics, do a roadmap of the whole house, do an entire timeline, present all of the evidence, and present all of the law, and let them make an independent determination, because that's what the community wanted. That's what the community needed. And instead he lied and told them he gave it to them when they didn't.